So now we have the pleasure of hearing from Lane County Commissioner Pete Sorenson.
Thank you very much. And at the risk of overheating, I wonder if this can be turned off here. Yeah? Okay.
It'll take a few seconds to...
It's superheating me up here.
It'll still blow for a few seconds.
Well, first of all, I want to thank Dr. Kalinge and Dr. Dart for arranging this program, and I really appreciate the presentation, not only that Dr. Dart made this evening, but also the presentation he made to the Eugene Water and Electric Board, which is available on YouTube. And in preparation for this evening, I watched it today, and I would highly recommend that you watch that, because you can play it back and slow it down, and in case you don't follow the number of statistics that are in there in a real-time way, you can stop it and play it back, and that really helps. And also, William Kalinge wrote the op-ed in the Register Guard that is excellent for the topic of what can people do at the local level about all of this. So I'm not going to talk about the health effects, but I am going to start off with not the health effects, but the fact that many local officials at the city and county level throughout the United States have been told that the Federal Telecommunications Act of 1996 prevents local governments, and that means cities and counties, from regulating cell phone towers based upon the health impacts. So all of the information that we've heard about the impacts of cell towers on human beings and their behavior and what causes the sickness and the correlation between the exposure and the sickness or the cancer or the interruption in your melatonin production and all kinds of other health impacts that Dr. Dart talked about. There are many local officials who are told at the point that they're sitting down to work on land use plans and zoning issues and siting of specific cell phone towers, they're told that the Federal Telecommunications Act prevents them from regulating those towers based upon health issues. And of course, most of us are here because we are precisely concerned about the health issues. So first thing I would like to do is recommend a law review article called Communication Tower Sightings, the Telecommunications Act, and the Battle for Local Control. And it's in the University of California Law Review, University of California at Berkeley Law Review, and it talks about the misconceptions about the federal powers to regulate the siting of cell phone towers, and in fact invites the view that it's not true, because in the act itself it says, nothing in this act shall affect the ability of a state to impose requirements necessary to protect public safety and welfare and safeguard the rights of consumers. So a lot of times local officials are told that there's nothing they can do because it is a federally preempted activity. And I know that, is Professor Wood, are you here? Yes, you are. So I hesitate to talk about law in front of a law professor who is as distinguished as Professor Wood is, but suffice it to say, the language in the Federal Telecommunications Act itself has invited opposition to the mainstream view, the view put forward by the telecommunications industry and the cell phone industry, that local governments in the United States, as opposed to Sweden or India or other governments in the world, that our government, our national government, has precluded any further discussion of this at the local level, at the local siting level. And so I just want to bring that up right at the outset, because when I was involved in drafting Lane County's cellular cell tower ordinance, we were repeatedly told this. And I actually asked the question, well, if we're prohibited from enacting a local ordinance, then why are we talking about enacting a local ordinance? And the answer is, well, you're not totally stopped from doing it. So my point is, let's try to push that envelope. Let's try to push it. And let's not accept the view that the industry advances, that there's nothing we can do. Secondly, Oregon has, as we all know, or should be taught in school, we have a unique state law. And when Governor Tom McCall was governor, and livability and making Oregon a beautiful place and keeping it a beautiful place was at the forefront of a political agenda, the Oregon legislature passed a law called the Oregon Land Conservation and Development Act. Now, this is a state law that says that the state expects local communities, cities and counties, to come up with land use plans that meet minimum state standards. And who decides whether they meet the standards? The state decides whether they meet the standards. And those standards are called the Oregon Land Conservation and Development Goals. And goal 1 of the goals is maximum public involvement in land use decisions. That is goal 1 of the goals. Now, of course, in the many years that have passed since we enacted the Oregon Land Conservation and Development Act, number 1, we got the goals. Somebody had to make up those goals. That was the Land Conservation and Development Commission, LCDC. And that commission is the one that sets up changes and modification of goals. And since cell towers weren't envisioned in 1973 when the Oregon legislature passed that law, and the health impacts and visual impacts, aesthetic impacts, historical impacts, wildlife impacts, and all kinds of other impacts were not known, it's my view that we should be advocating to get that into the current guidance to cities and counties. I will say that and also another thing that Oregon land use law does is that when a decision is made pursuant to a valid plan, and both Lane County and Eugene have valid plans, and they have to be reviewed periodically, when there is a decision made to do something under the plan, and there's a dispute about that, the appeal goes not into the court system of the trial courts and what we might think of as the county courthouse. Instead, it goes to an independent administrative tribunal called the Land Use Board of Appeals, LUBA, another acronym. And LUBA then decides whether or not the land use plan has been adhered to or not when it is presented with those disputes. I wanted to talk about a couple of cases to give us some hope that all of the information we just got wasn't going to just be discarded by subsequent proceedings in front of a hearings official or the Eugene Planning Commission or the Eugene City Council regarding the cell phone tower proposals in South Eugene. And I wanted to talk about a case up in Clackamas County called Morton versus Clackamas County. Now, the Mortons live near where AT&T wanted to put a cell phone tower. See if I remember the height. No, I don't. But it was a big one. It was out in rural Clackamas County, just south of Oregon City. And the neighbors had been fighting this, and the county had approved, the Clackamas County Board of Commissioners had approved, oh, it's 150 feet, a 150-foot cell phone tower. The neighbors then appealed the decision to LUBA, the Land Use Board of Appeals. And in July of this year, LUBA decided, July 8, that the county, in their determination, had said that the tower would not alter the character of the surrounding area. Now, this is a rural area. You can picture cows and horses and the occasional McMansion, but mostly farms. And the neighbors were able to show that the cell phone tower did impair the property surrounding the area where the cell phone tower was. The hearings official at the county had failed to address whether the visual impacts of the proposed tower would limit or impair the rural residential character of the area. So the LUBA reversed Clackamas County and said, no, you can't put the cell phone tower up. Another example, not so recent as July 2014, is a decision, not by LUBA, but at the county level itself. So this never got to LUBA, and that's where the neighbors were objecting to a cell phone tower along Interstate 5 south of Medford, a very high value location for a cell phone tower. And the local plan said, the zoning said that you could not put a cell phone tower within 200 feet of a residence. And this case illustrates something, and that is, we say in law, the first rule of understanding a code or a statute is to read the code or statute. That's the first rule. The second rule of statutory construction is to read the statute a second time. And you can imagine what the third rule of statutory construction is. Yes, it is to read the rule a third time. Well, in this case, the Jackson County Code said you can't put a cell phone tower within 200 feet of a house. And at the hearing, a person testified that their house was 180 feet from the cell phone tower proposal. So it was defeated. And that illustrates the point about trying to learn as much as you can about what you're facing. I am no expert on this. I was involved in writing our county's better cell phone tower ordinance, and part of the reason I came here, and by the way, this started out as William said, are you interested in doing having a meeting about cell phone towers? I said, yeah, I want to do a meeting because I want to plan a forum on the city and county regulation and changing and improving and strengthening the codes for the regulation of cell phone towers. And it would be nice to have a small group of people, I now know what scientists mean by the word small, to plan a little forum on this topic. So my main reason for coming was actually to say I'd like to do a forum on this because as a result of our cell phone tower regulation, it's my great fear that the cell phone industry is going to go to our Board of Commissioners and ask them to weaken the cell phone tower ordinance that I helped to pass in a more friendlier, environmentally friendlier era of Lane County government history. Sure, go ahead. Well, the reason I gave you a couple of positive examples from Oregon under Oregon's land use law is not to confuse the national picture of what other states, how they regulate cell phone towers, but to just give an example from Clackamas County and Jackson County where the same arguments are made about how health impacts are irrelevant, that the Federal Telecommunications Act of 1996, a federal law, preempts local governments from doing anything. Leave us alone, just approve it. We filled out your forms. We paid their money. Now we want our permit, okay? And I'm giving you two examples where they, the neighbors had fought it. And I will give you from my research, there's a group up in Portland called Neighborhood Notes. Has anyone heard of Neighborhood Notes? It's a website with the creative name www.neighborhoodnotes.com. And they are a group of Portland residents who advocate for increased scrutiny of cell phone tower location. And they have what I would call a bunch of advice they give to people. The first is, don't wait. Don't wait around for somebody who will learn more about it. Just jump in and try to learn as much as you can and start asking your elected officials, start asking your neighborhood, start asking as many questions as you can about these issues. Form a coalition. There are other people in the same boat. We know there's a couple of proposals right here in Eugene. And as I mentioned, there's also perhaps coming down the pike proposals to weaken the rural or at least unincorporated Lane County ordinance. Learn about the code. That's one of the things they mentioned is look in the code for all the things that you think apply in your situation. I'll give you an example of identifying the adverse effects. We already heard a lot about the health effects of it, but among the other things to look for would be the aesthetic effects. That is one thing that under Oregon law is very clear you can look for. Another one, and this was a decided case in Portland, was the National Historic Preservation Act protects certain neighborhoods from changes in that neighborhood if they meet criteria for historic standards. Another one related to aesthetic is the visual effects. Another one, which is how a group of Portland residents stopped a cell phone tower, is to pursue the applicants' the amount of information that the applicant has presented in their application about the alternatives to the sites where they want it to go. So the alternatives have to be presented as part of the presentation, and almost never is. Another one is the argument about preemption is that the federal government, through the passage of a federal law, stops you from citing health impacts. And ironically, we have in our Amazon Creek area, we have wildlife issues. And of course, this is a sad state of affairs when children, and I am wearing this tie out of respect for the fact that we know that children are more sensitive to these things than the rest of us. And it seems to me that if we see the impact of endangered plants, which exist in the Amazon drainage, and right, near here, behind me, I think, little disoriented on where we are, but basically, I think, isn't it this way? Yeah, and certainly that way. That wildlife impacts, and you saw a little bit of that data in Dr. Dart's presentation, those are also things. And last but not least on the advice is keep asking questions. Keep asking questions. So I'll just kind of close this off by saying, number one is learn what you can. Number two is work for the concept of getting local communities to have a right over the decision about where to locate these towers. That is a political effort going on nationwide, and it may or may not be relevant to all of these disputes, but I do think it's worth asking our senators and Representative DeFazio for increased authority and clear authority, so we don't have to argue about what the authority is, that local communities should have this right. And then work at the city level and the county level, not specifically on the proposal, but on the concept of amending, changing, strengthening, improving the local ordinances so that when people are, see these applications, they have a better idea of what their rights are and the timelines and the ability of getting an independent review as part of the application process. So I'm speaking for Dr. Dart here, but I'm sure we'd both be happy to answer questions about all this.